Key terms: abandonment, accession, accretion,
acknowledgement, action for declaratory relief, action to quiet title, administrator, adverse possession, after acquired title, alienation, alluvion, avulsion, bequest, certificate of sale, chain of title, codicil, color of title, common law, dedication, condemnation, decedent, deed, devise, devisee, deviser, easement, easement by, prescription, eminent domain, equitable estoppel, erosion, escheat, executor, forfeiture, gift deed, grant, grant deed, grantee, granting clause, grantor, holographic will, intestate, intestate succession, inverse condemnation, judgment, judicial foreclosure, action, legacy, legatee, partition action, power of sale, probate, probate code, quitclaim deed, real estate fraud, prosecution trust, fund, reconveyance deed, recording, reliction, request for, reconveyance, revocable transfer on, death, tod, deed, sheriff's deed, statutory dedication, tax deed, testate, testator, trust deed, trustee in bankruptcy, trustee's deed, warranty deed, will, writ of execution, summary. A person who dies testate leaves a will. The testator, decedent, can devise her property to a devisee. By bequest, a legacy of personal property can be transferred to a legatee. A formal witnessed will is a written document complying with legal formalities. A holographic will is written entirely in the handwriting of the testator. The law of intestate succession provides for distribution of the property of a person who dies without leaving a valid will. Land situated along a moving body of water may be increased by accretion, as alluvion, alluvium, is deposited on the shoreline. If water recedes, there may be reliction of land. The movement of water may diminish the land area at shoreline by avulsion. By occupying land for 5 years, paying taxes, and claiming possession, one can acquire title by adverse possession. Successive owners under color of title can tack their periods of ownership. An easement by prescription to travel over land may be acquired in a similar fashion, but without paying taxes. The holder of a leasehold interest may abandon that interest, and the landlord again may have the right of present use or possession. Title to real estate may be transferred by deed, whether private or public. Land may be dedicated to public use, as when a developer builds streets through a subdivision. Alienation is an involuntary transfer of title, an action to quiet title, a partition action, a foreclosure action, and an action for declaratory relief are some of the ways the courts can be called on to settle property disputes. A writ of execution by the court orders the sheriff to sell a debtor's property. The buyer receives a certificate of sale or a sheriff's deed. Title could change by forfeiture if a condition subsequent were breached. A trustee in bankruptcy may sell real property to acquire funds for creditors. The buyer receives a trustee's California_E_principles_10E_book.indb 99 the 23rd of May 2017 2:26 and 37 seconds p.m. 100 California Real Estate Principles 10th edition. Deed. Property acquired during marriage that is not separate property is community property. The right of eminent domain enables a governing body to condemn, or take, land for a public purpose. The actions of a property owner or prospective property owner may later equitably stop, or prevent, him from denying the property rights of another. Transfer of ownership of property by deed must name a grantor and grantee and describe the property to be conveyed. The correct words of grant must be used, depending on the type of deed. The deed is effective once it has been delivered to the grantee and accepted. If the grantor's action is acknowledged, the deed can be recorded and will enter the property's chain of title. Implied warranties are given in a grant deed by the grantor, who also may convey, after acquired title. A quitclaim deed gives no such warranties and cannot convey after acquired title, but it may clear a cloud on the title. A warranty deed gives express, stated, warranties. A trust deed enables a trustee to hold title until a debt is paid to the beneficiary by the truster. If the debt is paid, a reconveyance deed will put title back in the truster. A sheriff's deed is given following a forced sale of real estate. A revocable transfer on death, TOD, deed, when properly created, will transfer title without going through a probate proceeding. Open for discussion. A claim of title by adverse possession often is used as a fallback position when title is challenged by legal action. 1. When could such a claim be made? California_E_principles_10E_book.int 100 the 23rd of May 2017 2:26 and 37 seconds p.m. Unit 4 Transferring Real Estate 101 Review Questions 1. A person who dies without a will dies A. Testate B. Intestate C. With an executor D. In eminent domain. 2. The testator names A. An executor or executrix B. A testator C. A devisor D. An administrator or administratrix. 3. Someone who receives real property by will is called A devise B. A devisee C. A testator D. A codicil. 4. A typewritten will must be A. Made by a competent person B. Signed by the testator C. Witnessed D. All of these. 5. A statutory will is A. Signed and witnessed B. Telegraphic C. Oral D. Invalid. 6. A holographic will is A. Oral B. Telegraphic C. Handwritten D. Witnessed. 7. The probate court appoints A. An executor or executrix B. A testator C. A devisee D. An administrator or administratrix. 8. Whence oil is deposited on a riverbank, gradually building out the land, this process is called A. Accretion B. Alluvion C. Avulsion D. Subsidence. 9. When flood conditions cause land to be washed away, this is known as A. Accretion B. Alluvion C. Avulsion D. Accession. 10. When water recedes, creating a new shoreline, the process is called A. Accretion B. Alluvion C. Avulsion D. Reliction. 11. Elena moves onto Mike's land, builds a home, pays the property taxes, and claims she owns the property. When will she have good title, even against Mike? A. After 1 year B. After 3 years C. After 5 years D. After 10 years. 12. Elena's friend Cal, who used to own the property in question 11, gave her a phony deed to Mike's land. Elena, who does not know the deed is phony, has A. worthless document. B. Color of title. C. A good title. D. To share the title with Mike. 13. The right to travel over the property of someone else is A. An easement. B. Equitable estoppel. C. A fixture. D. Statutory dedication by deed. California_E_principles_10E_book.int 101 the 23rd of May 2017 2:26 and 37 seconds p.m. 102 California Real Estate Principles 10th edition. 14. A co-tenant who wants property that is co-owned to be sold would bring A. A foreclosure action. B. An action for declaratory relief. C. An action to quiet title. D. A partition action. 15. In event of default, real property may be sold without court action if the mortgage or other lien instrument contains A. A trust deed. B. A power of sale. C. A tax deed. D. A right of entry. 16. The court order following a judgment for money is A. A certificate of sale. B. A special limitation. C. A writ of execution. D. A trustee in bankruptcy. 17. The power of the state to take private property for public use is called A. Eminent domain. B. Equitable estoppel. C. A public grant. D. Abandonment. 18. To be effective, a deed must be A. Made on a printed form. B. Signed by the grantor. C. Delivered to the grantee by the grantor personally. D. All of these. 19. The transfer of title from grantor to grantee, and from that grantee to a subsequent grantee, and so on, is called A. A cloud on the title. B. The chain of title. C. Delivery and acceptance. D. An acknowledgement. 20. Legal title conveyed by a deed of trust may be regained by A. A warranty deed. B. A trust deed. C. A reconveyance deed. D. A sheriff's deed. Transferring real estate. Learning objectives. When you have completed this unit, you will be able to describe what happens when someone dies and leaves a will. A. Describe how the California law of intestate succession affects the disposition of community property and separate property. A. List the steps involved in a probate sale of real estate. A. Identify the ways in which property can be increased or acquired that do not involve a purchase. A. Define the ways in which title to property can be transferred. A. Explain the requirements for a valid deed. And A. List the types of deed used in California. How real estate may be acquired. When California was still under Spanish and Mexican rule, no written document was needed to transfer title to California land. A buyer could take title by taking possession at the time of sale. The seller would hand over to the buyer some part of the land, perhaps a twig or clump of dirt, to show transfer of ownership. California courts eventually decided that a written document was necessary to transfer title to land. An exception was made for a contract of sale, in which case the transfer of possession in the old ceremonial way was permissible. After California became a state, the legislature authorized the placing of a written document of transfer in the public records to provide evidence of a land transaction. A deed that is recorded in the county recorder's office is the modern equivalent of the ceremonial transfer of possession. Real estate can be acquired in any of the following ways, which are discussed in this section. A. The estate of someone who dies. A. Improvements to land. California_E_principles_10E_book.int. The 23rd of May 2017, 2:26 and 14 seconds p.m. Unit 4. Transferring real estate. 81. A. Natural forces. A. Possession of someone else's property. A. Transfer from a private or public owner. A. Alienation by operation of law or court action. Will or succession. Perhaps the least complicated way to acquire title to real estate is to receive it as part of the estate of someone who has died. The deceased can name the property's new owners in a document called a will. If the decedent of the person who died leaves no will, the law determines the property's new owners. Succession. A person who dies without having made a will is said to have died intestate. All states make provision by law for distribution of the property of intestate persons. This legal determination of property ownership is called intestate succession. Figure 4.1 shows how property ownership is determined under California law. The law applies to both real and personal property. Community, quasi-community, and separate property were defined in Unit 3. For example, a married couple own Sunny Acres as community property. The couple have no children, who will have title to Sunny Acres if one of the spouses dies without a will. If the couple have 8 children and one spouse dies without a will, who will receive title to Sunny Acres? If a spouse dies without a will specifying otherwise, that spouse's half of the community property, including Sunny Acres, will go to the surviving spouse regardless of the number of children. The surviving spouse already owns the other half of Sunny Acres, because it is community property. When the first spouse dies, the surviving spouse will own all of Sunny Acres. A will is a document made by an owner of property who is legally competent to do so, to pass title to the property to another after death. The person making a will is called the testator, property owner, and is said to die testate. The transfer of title to real estate by a will is called a devise. The deceased owner is the deviser, property owner. The person receiving property by will is a devisee. The transfer of property by will, particularly personal property, is also referred to as the bequest of a legacy. The recipient is a legatee. A transfer of title by will takes effect on the death of the testator. During life, the testator has the right to make a new will or to change a will by adding new or amended provisions through a document called a codicil. For this reason, until the testator's death, a devisee has no present interest in the property interest specified in a will. A codicil is the easiest way to change the terms of a will. California_E_principles_10E_book.int. 81 the 23rd of May 2017, 2:26 and 14 seconds p.m. 82 California Real Estate Principles 10th edition. Figure 4.1 Intestate succession. California law of intestate succession. Community property. If there is a surviving spouse, A1 A2 already belongs to surviving spouse A. Remaining 1 A2 goes to surviving spouse after decedent's liabilities have been paid. Community property with right of survivorship. If there is a surviving spouse takes entire property. Separate property. If there is a surviving spouse and no child, a surviving spouse takes 1 A2. A surviving parent, brother or sister or child of deceased brother or sister, or A, if none of these, spouse takes 1 A2. If there is a surviving spouse and one child, a surviving spouse takes 1 A2. A child takes 1 A2. If there is a surviving spouse and more than one child, a surviving spouse takes 1 A3. A children divide 2 A3 equally. If there is no surviving spouse or child, a property is distributed to next of kin in order prescribed by California law. If no heirs can be located, the property will escheat to the state. There are two types of wills currently recognized in California: the formal witnessed will and the holographic, handwritten, will. Oral wills are no longer considered legally valid in California. California statutory will. To encourage people to make a will, the California Bar Association has prepared 2 printed will forms that are available to the public. The California statutory will form provides for disposition of the testator's property to the named devisees, typically the testator's spouse and/or children. Space for witnesses' signatures is included. The California statutory will with trust form provides for the establishment of a trust that will hold property for children of the testator until the youngest child is 21 years old. The property held in trust could be used by the named trustee, manager of the trust, for the support and education of the children before the youngest is 21. The statutory will forms can be obtained from the State Bar of California, 555 Franklin Street, San Francisco, or 1149 South Hill Street, Los Angeles. Addresses of Bar Association offices can be found at www.calbar.car.gov. Stationery supply stores also may carry statutory will forms. www.calbar.car.gov. California_E_principles_10E_book.imp 82 the 23rd of May 2017 2:26 and 14 seconds p.m. Unit 4 Transferring Real Estate 83 Witnessed Will. The formal witnessed will is a written document. It is normally prepared by an attorney and signed by the testator. The will lists all of the testator's property, specifying the desired disposition of that property on the testator's death. After the testator declares the will to be his, the testator signs it in the presence of at least 2 witnesses, who then sign the will at the testator's request and in the testator's presence. Holographic will. A holographic will is one written by hand, dated, and signed by the testator. A holographic will does not need to be witnessed, but it must be entirely handwritten. There can be no printed or typewritten parts of a holographic will. Probate. When properly drawn, a will names an executor to act as the decedent's representative in ensuring that the terms of the will are carried out. Probate is the name of the court process that determines the decedent's heirs and creditors, pays debts owed by the estate, and transfers title to any remaining property from the decedent to the decedent's heirs. If there is a will, the decedent's representative presents the will to the probate court and receives permission to carry out its provisions. Sometimes, the deceased leaves no will or fails to name representative, or the named representative refuses to serve in that capacity. In any of those cases, the court may appoint an administrator to handle the estate. Duties of the estate representative include the following: A. Publishing a notice to creditors of the decedent's death. A. Conducting an inventory and obtaining an appraisal of the property in the decedent's estate. A. Making a report to the probate court of the estate assets and liabilities. A. Distributing the proceeds of the estate as the court directs with the court's approval. Estate representatives and attorneys may be paid a fee. Expenses incurred in administering the estate, federal and state estate taxes, and claims of creditors are provided for as the probate court approves. Any estate property remaining is distributed to the heirs and devisees. Probate sales of real estate. The probate code governs the sale of real property that is part of a probate proceeding. The executor or administrator may sell real property if it is in the best interests of the estate to do so, such as to pay debts or make specific bequests. For probate sales, the following apply. The real property may be offered for sale by the estate representative directly or through one or more brokers. With court permission, the estate representative may grant an exclusive right to sell the property for up to 90 days. The estate representative can accept an offer that is then subject to court confirmation. Broker commissions are subject to statute and court approval. A holographic will is valid if the signature and material provisions are in the handwriting of the testator. California_E_principles_10E_book.ind 83 the 23rd of May 2017 2:26 and 14 seconds p.m. 84 California Real Estate Principles 10th edition. Accession refers to an increase in the property owned. Man-made or natural additions to property may extend the owner's title to include those additions. These can occur by the construction of improvements or by the process of accretion or reliction. Improvements: if a landowner puts up a building on the land, that man-made improvement becomes part of the owner's title to the land. If a fixture, such as a new heating system, is added to an existing building, the fixture then becomes part of the real property. The unintended improvement: sometimes, an improvement is added to land by mistake. There may be a mistake in the address given to the builder, or the lot may have an incorrect address posted on it. Sometimes, the legal description in a deed is recorded incorrectly. California law provides for what is known as a mistaken improvement. If a fixture is added to property by a person who acted innocently but on mistaken belief as to the property's owner, the fixture may be removed. The owner must be compensated for any damage to the property. The law thus protects an individual acting in good faith but under a mistake of fact, such as property location, or a mistake of law, identity of the rightful owner. Accretion: land area can be increased by forces of nature. Accretion is the process by which land adjacent to a flowing body of water accumulates new soil. The buildup of new soil, called alluvion or alluvium, may be so gradual that it is not noticed. Buildup also can be quite dramatic and obvious, as when land is flooded. For example, a family owns a vacation cottage on the Russian River. Over the years, the river has deposited soil at the waterline. The property's shoreline now extends 1 foot farther than the last recorded distance to the nearest landmark, a marker in the roadway. Has there been any increase in the square footage owned by the family? Yes. A survey would show that the total property has increased due to accretion. But land also may be lost. The natural force of a moving body of water acting gradually or suddenly may wash away or tear land in a process called avulsion. You should note that avulsion is distinct from erosion, the process by which precipitation, rainfall, wears away the surface of the soil. Reliction: waters of any moving body of water may permanently recede, uncovering new land that was once under the water. This process, called reliction, increases the adjacent owner's property. Occupancy: sometimes, you can acquire an ownership right to property by occupying, using it. Your use must be without the present owner's permission, and the land cannot. Unit 4: Transferring real estate. 85B. Publicly owned. The following are 3 ways in which property, or the right to use property, can be acquired by occupancy. 1. Adverse possession. 2. Prescription. 3. Abandonment. Adverse possession: the concept of taking over someone else's property and occupying it long enough to acquire ownership of it can be appealing, but the reality is much more complex and rarely accomplished. You can acquire title to real estate by adverse possession if you follow these 5 steps. 1. You must occupy the property openly and notoriously, that is, without hiding the fact from anyone. 2. Your occupancy must be hostile to the true owner's interests, in other words, without permission. 3. You must claim title to the real estate, whether your claim of right is initiated by the fact of occupancy or by color of title. Color of title is there, possession of a document erroneously appearing to convey title to the occupant. Land boundaries must be fenced or otherwise documented. If the person in possession has color of title, that document will provide a legal description of the land. 4. There must be continuous possession for a period of 5 years. You cannot abandon the property during that time, no matter how briefly. 5. You must pay all real property taxes during the 5 years of possession. An easy way to remember the requirements for adverse possession is by using the acronym ONCHA. The possessor's occupancy must be A. open, A. notorious, A. continuous, A. hostile, and A. adverse to the interests of the real owner for 5 years. Although the occupancy must be continuous for 5 years, successive adverse holders may add together, or tack, their periods of occupancy. Successive occupiers must take possession under color of title, which means that the new occupier receives a deed from the previous occupier. Even though the deed would not survive a challenge by the property's owner, it must appear on its face to be valid. Title acquired by adverse possession cannot be insured and generally cannot be conveyed until it has been verified by court decree. The court decree can then be recorded in the county recorder's office. California_e_principles_10e_book.imp85 the 23rd of May 2017 2:26 and 14 seconds p.m. 86 California Real Estate Principles 10th edition. For example, Floyd would like to own the acreage next to Mustang Canyon. The Hendersons own the land but rarely visit it. Floyd moves onto the property, builds a shack, fences in 50 acres, and places a sign, Floyd's Ranch, over the locked entrance gate. Whenever anyone asks about his use of the property, he tells them, "It's mine." Floyd pays the property taxes and lives only on their property. After 2 years, Floyd sells all right, title, and interest of whatever kind in the ranch to Judd, giving Judd a deed. Floyd moves off the ranch and Judd promptly moves in, bringing his spouse and 6 children with him. Judd pays the property taxes and proclaims to everyone that he now owns Floyd's Ranch. After about 3 years, Judd sells Floyd's Ranch to Aria, who in good faith records the deed Judd gives her and moves onto the land. A few months later, Harry Henderson shows up and is quite upset over what he finds. It has been more than 5 years since Floyd first moved on to the land. Who owns the land? Aria owns the land. The adverse possession begun by Floyd and continued by Judd and Aria under color of title ripened into good title at the end of 5 years. Aria will have to bring a legal action to quiet title, discussed later in this unit. To get the court decree, she needs to give notice to the world of the validity of her title. Prescription: the right to use or to travel over someone else's land is called an easement. If an easement is used without permission and the user fulfills all the other requirements for adverse possession except for paying property taxes, an easement by prescription will be created. The use must be exclusive. This means that the person claiming the easement is doing so as the assertion of a private, rather than a public, use. The easement right will be recognized as a result of legal action or by agreement of the parties. For example, Marcy owns a small house in La Jolla, California. Although Marcy's house is on a quiet, meandering residential street, she would prefer to have a more direct way to reach the commercial street that lies on the opposite side of the property behind hers. One day, Marcy discovers that there is just enough room along the side of her neighbor's lot for her to drive her car across her neighbor's property to the commercial street. She proceeds to do just that and does so at least once a day for the next 6 years. Marcy and her neighbor never discuss her use of what has taken on the appearance of a driveway. One day, when she drives home after work, she discovers that her neighbor has erected a chain-link fence across the front of his property, blocking the entrance to the driveway she has been using. Does Marcy have the right to object? Yes, Marcy can object to the fence her neighbor has built. By her continuing use of the driveway for more than 5 years, Marcy has acquired an easement by prescription to that portion of her neighbor's property. The neighbor may build a fence, but there will have to be a gate so that Marcy can have access. In the previous example, what would happen if Marcy decided to stop using the driveway across her neighbor's lot? Just as an easement by prescription can be acquired by use, it can be lost by non-use. If the holder of an easement by prescription fails to use the easement for 5 years, the easement right is extinguished. An individual can claim an easement by prescription. California_E_principles_10E_book.imp 86 the 23rd of May 2017 2:26 and 14 seconds p.m. Unit 4 Transferring Real Estate 87 Abandonment. If leased property is abandoned by the lessee, tenant, the lessor, landlord, has the right to reacquire its possession and use. Abandonment is more than simple non-use. A lessee abandons the leasehold interest by leaving the premises and acting in a way that is inconsistent with continuing possession, such as by failing to make rent payments when due, removing one's property from the premises, and filing a change of address with the post office. Transfer. The ways in which title to real estate can be transferred from the present owner to someone else are highlighted in Figure 4.2 and explained next. Figure 4.2, Ways to transfer real estate. A private grant, a public grant, a public dedication, a alienation by operation of law or court action, a execution, sale, a forfeiture, a bankruptcy, a marriage, a escheat, a eminent domain, a equitable estoppel. Private grant. A private grant, also called a grant deed, is a written instrument giving the names of both parties and a legal description of the property. The transfer of ownership may be a gift, which requires no consideration, payment, for their deed. The requirements for a deed are explained later in this unit. Public grant. Title to real estate that was not passed by land grant and affirmed after the war with Mexico became public land and part of the territory of the United States. Some public land became the property of the state of California after statehood was granted. It is still possible for the federal or state government to deed public lands by public grant to private parties, as is done when old military installations are sold to developers. For example, Fort Megan is an Air Force base that has not been used for 25 years because its runways are too short for modern aircraft. The base buildings are in disrepair, and the old landing strips have been devastated by earth movement and neglect. Nevertheless, Fort Megan is located in a densely populated urban area and could be sold for a high price per acre for any purpose allowed by local ordinances. Public dedication. Private land can be transferred for public use or ownership by common law dedication, statutory dedication, or deed. A common law dedication occurs when a landowner devotes land to a public use, as when a roadway is open to public use or described as such in the deeds to California_E_principles_10E_UO4.IND 87 the 26th of May 2017 10:07 and 10 seconds AM 88 California Real Estate Principles 10th edition. Adjoining parcels under the requirements of the Subdivision Map Act, described in Unit 15. Certain areas will be set aside for public use, such as parks, school grounds, and streets. This statutory dedication generally transfers an easement for the intended public use, although transfer of fee simple ownership by deed is becoming the preferred method of public acquisition. Fee simple title preserves the public character of the land despite the failure of the subdivision itself. Alienation by operation of law or court action. It is possible to bring a legal action in court for the purpose of clearing or establishing title to real estate, despite the opposition of the owner of record. Alienation, transfer, of title may be involuntary, that is, without the original owner's consent. An action to quiet title is brought to force others who have claims to the property to prove those claims or have the claims ruled invalid by the court. This is the usual method of establishing title by adverse possession and of clearing tax titles or title acquired on a forfeited contract of sale. A partition action is brought by a co-owner of property to force a severance of the co-owner's respective interests. As explained in Unit 3, the co-owner can be a tenant in common or a joint tenant. The property is divided, if possible, or sold. After a sale, the court divides the proceeds according to the owner's shares. For example, Linda and Sheila, twin sisters, own a house as tenants in common. Linda wants to sell her share but can't find a buyer, and Sheila doesn't want to sell. What can Linda do? Linda can bring a partition action in court. The court will sell the house unless the property can be divided into 2 equal parcels, and it will distribute the proceeds to the 2 sisters. A power of sale gives the trustee under a trust deed the ability to sell the property. To satisfy the unpaid debt if the debtor defaults, a mortgage or another lien document also may provide a power of sale for the mortgagee or lienholder. Trust deeds and mortgages are discussed in Unit 8. In a judicial foreclosure action, the holder of a trust deed, a mortgage, or other lien on property requests a court-supervised sale of the property to cover the unpaid balance on the delinquent debt. In an action for declaratory relief, the parties petition the court for a determination of their respective rights before a controversy arises. When a deed is ambiguous, an action for declaratory relief may be brought to avoid later problems. Execution sale. The party who wins a legal action may receive a judgment from the court that includes the award of money damages against the losing party. The holder of the judgment can file the judgment in any county in the state in which the debtor owns property and then seek a writ of execution. A writ of execution is a court order directing the county sheriff or another officer to satisfy a judgment out of the debtor's property. The property available to satisfy the judgment includes any non-exempt real property owned by the debtor. The property is sold at public auction, and the proceeds are used to pay the judgment. If you buy real estate at an execution sale, you will receive a sheriff's deed. California_E_principles_10E_book.int 88 the 23rd of May 2017 2:26 and 14 seconds p.m. Unit 4 Transferring real estate 89 When personal property is sold at auction, the buyer receives a certificate of sale. When real property is sold at auction, the buyer receives a sheriff's deed. The officer who conducts the sale must record a duplicate of the sheriff's deed in the office of the county recorder. Forfeiture. Forfeiture occurs if a condition subsequent in a deed is breached. The grantor, or the grantor's successor, then has the right to reacquire title. Bankruptcy. The U.S. Congress has sole authority to enact bankruptcy laws, and it enforces those laws through the federal bankruptcy courts. In a liquidation bankruptcy, a debtor's property is sold to cover debts. The trustee in bankruptcy carries out the sale, and the buyer receives a trustee's deed. Marriage. Property acquired during marriage or by registered domestic partners that is not separate property is community property by operation of law, as explained in Unit 3. One spouse acting alone cannot defeat the other spouse's interest in that property. As cheat. California law presumes that every person who dies has an heir who could take title to the decedent's property. Sometimes, however, it is impossible to locate an heir. The Attorney General acts on behalf of the state to bring a claim against the estate and, if no claimant comes forward within 5 years, title to the property vests in the state. This process is called escheat. Eminent domain. The federal and state governments have the right to acquire title to property by eminent domain. If property is for a public purpose such as highway construction, it is first subject to condemnation, a process that gives notice to the property owner that the property is being taken. The property owner receives compensation based on an appraisal, which usually is the property's fair market value. Fair market value, the price a property should bring on the open market, will be explained more fully in Unit 13. Sometimes, property that has not been condemned is damaged or its use is affected by a nearby public activity. When that happens, the affected property owners may seek money damages in a legal action claiming inverse condemnation. For instance, if a new highway blocks off the access road to adjoining properties, those properties will lose value. The property owners will expect to be compensated for the loss in value. The U.S. Supreme Court, in Keller v. New London, 545 U.S. 469, 2005, held that, Private property can be condemned by a public entity for transfer to a new private owner to further economic development. There was a strong response to this decision at all levels of government. President George W. Bush issued an executive order in 2006 limiting the federal government's use of eminent domain to purposes that benefit the general public and not merely for the purpose of the economic interest of private parties. Various states, including Arizona, have passed legislation prohibiting use of eminent domain for other than public purposes. Proposition 99, passed by California voters in 2008, amends the state constitution to affirm existing California law by prohibiting state and local governments from 90 California Real Estate Principles 10th edition, acquiring an owner-occupied residence by eminent domain for conveyance to a private person or business entity, with a few exceptions. Equitabilis topple: a person may convey or appear to convey a property, interest she does not yet own but may acquire at some future time. Such after acquired title must be transferred to the new owner. The doctrine of equitable estoppel, a common law theory meant to prevent unjust enrichment, prohibits a refusal to make the transfer. Equitable estoppel also prevents fraud or misrepresentation by the present owner of property. If a property owner misrepresents her ownership, whether by act or omission, to a person who then buys the property from another person who is the apparent owner, the true owner must convey the property to the innocent party. For example, Max owns Black Oca but does not want Jose to know. One day, when Max, Jose, and Carlo are together, Jose asks Max and Carlo if one of them owns Black Oca. Carlo says he owns Black Oca, and Max doesn't object. Jose then pays Carlo for Black Oca. Who owns Black Oca? Jose owns Black Oca. Max is equitably estopped from denying Jose's ownership. By his conduct, Max allowed Jose to believe he was buying Black Oca from Carlo. Max will be left with an action for damages against Carlo, who has pocketed the money Jose paid for Black Oca. Exercise 411. George married Helen in January 2008. In March 2010, Helen's father died, leaving Helen his condominium in Palm Springs. Who owns the condominium and in what form of ownership? 2. George and Helen, who married in 2008, purchased a house in 2012. Who will the law presume to own the house and in what form of ownership? 3. In 2016, George and Helen are notified by the city that their property is being considered as the site of a new sports arena. They protest the city's plans at a public hearing but are unsuccessful in halting the construction. Can the city take their house? 4. George and Helen paid $746,000 for their house in 2012. In 2016, the city offers them $746,000 for the property. Do they have to accept? 5. George decides to leave his half of the community property he owns with Helen to his sister Davida and has a will drawn up to that effect. When George dies, Helen is surprised when Davida claims to own half of her home. Can George do that? California_E_principles_10E_book.indb 90 the 23rd of May 2017 2:26 and 14 seconds p.m. Unit 4 Transferring Real Estate 91-6. Angel knows that squatters have moved onto the back 40 of his ranch and have even put up a fence. But Angel is too busy to do anything about it. Even after he hears that the squatters are building a house, Angel doesn't object. He feels smug that somebody is stupid enough to build a house on his land and pay taxes, to boot. 6 years later, Angel tries to sell his ranch, but the buyer says that he can't get a loan because Angel doesn't have clear title to all the land. Angel brings an action to quiet title in court. Will he win? 7. Tim Brown holds a mortgage on the house of Sarah Nelson, who is having financial difficulties and has missed all of her mortgage payments for the past 6 months. What can Tim do? 8. Uncle Henry died without a will. Did he die testate? What is the name of the legal process by which his property will be distributed to his heirs? 9. Lydia and Miguel own a small resort on the Colorado River with about 200 feet of lawn on a small bluff overlooking the river. Following torrential rains and flooding, Lydia and Miguel find they have only 130 feet of lawn area. What happened to the 70 feet of ground? What is this process called? Deeds. A deed is the document that transfers title to real property. There are many types of deeds that can be used to convey title to real estate. This section describes the requirements for a valid conveyance by deed and examines the different forms of deeds and their legal distinctions. Elements of a valid deed. A deed is a written instrument that, when properly executed, delivered, and accepted, conveys title to real property. Title is conveyed by grant, transfer, from one person, the grantor, who is the property owner, to another, the grantee. The words of conveyance appear in the granting clause. Transfer of title by deed may be the voluntary or involuntary act of the parties, as in the case of a foreclosure sale when title is transferred by operation of law. The specific legal requirements for a valid deed are listed in Figure 4.3. If all of the requirements for a valid deed are not met, the deed may be questioned even years after the property has been conveyed. California_E_principles_10E_book.indb 91 the 23rd of May 2017 2:26 and 14 seconds p.m. 92 California Real Estate Principles 10th edition Figure 4.3. Requirements for a valid deed. 1. The deed must be in writing. 2. There must be a description of the parties. The full name and marital status of each should be given. 3. The grantor must be legally capable of executing a written conveyance. Generally, this means the grantor must be an adult of sound mind. The requirements are the same as those to create a valid contract, discussed in Unit 7. The grantee of a gift can be an incompetent or a minor but cannot be a fictitious person. 4. There must be an adequate description of the property being conveyed, preferably using one or more of the methods discussed in Unit 2. 5. There must be a granting clause in which the necessary language of conveyance is used, such as the words grant or convey. The words to have and to hold, the habendum clause, are not necessary. 6. The deed must be signed by the grantors. 7. The deed must be delivered to the grantee and accepted by the grantee. The grantor must have the present intention of conveying and the ability to convey the property. For example, Ted gives a deed to Nicole, telling her it will take effect on his death. Is the deed valid? The deed is not a valid conveyance, even at Ted's death. Delivery means exactly that. The grantor holds nothing back. There can be no conditions. It is possible to deliver a deed to a third party to be released to the grantee on their fulfillment of a condition precedent. In that case, however, the acceptance is conditioned, not the delivery. A condition subsequent might be placed in the deed itself. That would invalidate it if the grantee failed to fulfill the condition. Note that although there is no legal requirement that a deed be dated, in practice, dating a deed is preferred because delivery and acceptance will be presumed to have occurred on that date. You should remember that a deed is not a contract. A deed has different elements and is subject to different rules regarding validity. The elements of a contract are discussed in Unit 7. A deed, unlike a contract, does not need to be supported by consideration. That is, the grantee does not need to pay anything in return for the conveyance. If fraud is suspected, however, as when property is deeded without consideration or with nominal consideration, say, $10 shortly before the grantor declares bankruptcy, the deed may be set aside by a court. There is no legal requirement that a deed be witnessed, that the grantor's signature be verified by any third person, or that the deed be recorded in the county recorder's office. Nevertheless, these steps are practical necessities to prevent future problems. Acknowledgement and recording of deeds are discussed following the exercise. Love and affection are the only considerations needed for a valid deed. California_E_principles_10E_book.indb 92 the 23rd of May 2017 2:26 and 14 seconds p.m. Unit 4 Transferring Real Estate 93. Exercise 4.2 Assuming all other requirements have been met, has a valid deed been created in each of the following cases? 1. Gerald Stone is selling Greenacre, the family estate. Gerald is out of the country at the time the sale is to be closed but phones the broker handling the transaction to tell her to go ahead with the sale and deliver possession to the buyer. Gerald intends to sign the deed when he returns. 2. Aunt Nellie is incapable of caring for herself. To help her out, her niece Roberta takes Aunt Nellie into her home. In return, Roberta asks Aunt Nellie to deed her condominium to her. Aunt Nellie does not realize what is happening, and Roberta guides her hand as she signs a deed. Who owns the condo? 3. Jed is a high-powered real estate investor. Over the phone he persuades Sol to sell him a 20-unit apartment building in San Diego. Jed is anxious to get the property and tells Sol to convey the property to him over the phone while his secretary takes notes. Jed tells Sol, "Your word is as good as gold." 4. Angela Dell agrees to sell her farm to her friend Diego. The deed from Angela describes the property as the old Dell place, including 100 acres, more or less. Does Diego have a problem? 5. Uncle Anthony decides to make a present of his Hillsborough estate to his nephew Richard. He prepares a deed, reciting love and affection as the consideration, and places the deed in an envelope marked, "To be opened upon my death." He then places the envelope in his safe deposit box. Will Richard own the estate when his uncle dies? Acknowledgement and recording. California law requires that most written instruments affecting title to real property be acknowledged before they can be recorded in the county recorder's office. Besides deeds, those instruments include the following: A loan documents, A agreements for sale, A option agreements, A deposit receipts, A commission receipts, any affidavits concerning one of these documents. California_E_principles_10E_book.indb 93 the 23rd of May 2017 2:26 and 14 seconds p.m. 94 California Real Estate Principles 10th edition. A document does not have to be recorded to be valid. The process of recording is important, however, because it is the primary way to give notice to the world of an interest that affects title to real estate. Acknowledgement: a document is executed when it is signed. A person who has executed a document can make a declaration, called an acknowledgement, that the execution is the person's own act. An acknowledgement may be made anywhere within California before an authorized official, typically a notary public, or who cannot be a party to the transaction or related to a party to the transaction. An acknowledgement may be made outside California if local laws are followed and that fact is certified by the person taking the acknowledgement. Persons authorized to take an acknowledgement in California include judges, court clerks, and notary publics. A notary public, in addition to signing the document, must stamp it with the seal required by the state. When notarizing a deed, including a quitclaim deed or deed of trust, discussed later in this unit, the thumbprint of the grantor must be placed in the notary's official journal. An acknowledgement alone, without recording the document, serves as notice of the conveyance to the parties and to persons knowing of it. Possession of the property involved also gives notice of ownership. The legal protection of an acknowledged but unrecorded document is not very great. The ordinary transaction does not involve many people, and only those who already know of their transaction are considered aware of it. Recording: the safest way of ensuring that one's title to property is unquestioned is by recording the deed that conveys the property. The deed is brought to the office of the county recorder in the county where the property is located. As a general rule, first in time is first in right. This means that, if more than one person claims title from the same grantor, the first to record a deed will be the successful claimant. To be recorded, a deed must give an address of the grantee to which tax bills can be sent. A county may add up to $2 to its recording fees for a real estate fraud prosecution trust fund to help district attorneys and law enforcement agencies deter, investigate, and prosecute real property fraud crimes. Unit 4 Transferring Real Estate 95 Building the chain of title. The recorder's office files instruments under the parties' names, so the full name of both grantor and grantee must be given. If the grantor's name is not given exactly as it appears in the conveyance to the grantor, it may not be possible to complete that link in the chain of title. Most title searches are conducted by tracking the grantor's interest backward in time, then tracking the first recorded grantee's interest forward. To discover all the links in the chain of title, the grantor of the present conveyance should be found as the grantee of a preceding conveyance. The grantor of that conveyance should be the grantee of an earlier conveyance, and so on. Although variance in the use of a middle name is not necessarily fatal to the validity of a deed, the better practice is to use the full name rather than an initial in place of the middle name. A fictitious name, or alias, may be used to receive title to property, provided the same name is used in any subsequent conveyance. Title cannot be conveyed to a fictitious person, however. Title can be conveyed to a corporation, because a corporation is a recognized legal entity. The system of making documents a part of the public record works to the advantage of the property owner as well as a prospective buyer or lessee. The property owner is able to give constructive notice to the world of the fact of his ownership. In theory, by inspecting the public record, the prospective buyer or lessee can have the confidence of knowing that he is dealing with the recorded owner of the property. The buyer or lessee still needs to verify that someone else isn't in possession of the property. Of course, financing instruments are also recorded to give constructive notice of the lien rights of the lender and are discussed in Unit 8. Types of deeds. Grant deed. A typical form of grant deed appears in Figure 4.4. Notice that the form contains the word grants. The deed form is simple and provides for the deed to be acknowledged and recorded. The grantor makes implied warranties in executing a grant deed. These are items the grantee must assume to be true, or the deed would be meaningless. Implied warranties are legally enforceable even though they are not mentioned in the deed. The grantor warrants that other grantors' interest in the property has not already been conveyed, and there are no undisclosed encumbrances on the property, such as taxed liens, brought about by the grantor or any person who might claim title from the grantor. California_E_principles_10E_book.indb 95 the 23rd of May 2017 2:26 and 14 seconds p.m. 96 California Real Estate Principles 10th edition Figure 4.4 Individual Grant Deed. Source: reprinted by permission of Stewart Title of California, Incorporated. Note that the grantor does not warrant that she has a present interest in the property to convey. If the grantor attempts to convey property the grantor will acquire, after the execution of the grant deed, the deed will become effective at the time such after acquired title is received by the grantor. The grant deed is the only form of deed that conveys after acquired title. California_E_principles_10E_UO4.IND 96 the 24th of May 2017 10:23 and 7 seconds AM. Unit 4 Transferring Real Estate 97 Gift Deed. Although the grant deed form leaves space for the consideration paid by the grantee, it may be used to convey property as a gift deed by supplying the words love and affection as the consideration received. As noted earlier, such a conveyance may not be made to defraud creditors of the grantor. Quitclaim deed. A quitclaim deed conveys any interest the grantor may have in the property at the time the deed is executed. No implied warranties are made by a quitclaim deed, and there is no express or implied warranty that the grantor owns any interest at all in the property. A quitclaim deed should never be used when a grant deed can be used. A quitclaim deed does ensure that whatever interest the grantor may have in the property is conveyed to the grantee. The quitclaim deed is a commonly used way of clearing a cloud on the title and eliminating any future claim by the grantor of the quitclaim deed. There can be no after-acquired title with a quitclaim. However, the grantor of a quitclaim deed remains liable for any loans made using the property as security. For example, Harvey Anderson bought Whitaker after he married Anna, but Harvey used money from the sale of his separate property to do so. When Harvey sold Whitaker, he signed the deed as Harvey Anderson, a married man. His spouse did not sign the deed. The grantee of Whitaker questioned the validity of that conveyance when years later a would-be purchaser was unable to acquire title insurance. The cloud on the title of the present owner of Whitaker was cleared by having Anna Anderson sign a quitclaim deed, relinquishing whatever claim she might have in the property. Warranty deed. A warranty deed expressly warrants that the grantor has good title. The grantor's warranty makes the grantor liable for a flaw in the title affecting the buyer's interest that may be discovered later, even if the grantor had no previous knowledge of it. This form of guarantee, while attractive to a property buyer, could be devastating to a property seller. It is one reason why title insurance is required, particularly by lenders, In most transactions in California, by shifting the liability to the insurer, the seller can be assured that there will be no future liability caused by an undiscovered defect in the seller's title. In turn, the buyer can rely on the resources of the title insurer if any problem covered by the title insurance should arise. Trust deed. The trust deed, also called deed of trust, shown in Figure 8.3, is used when property serves as security for a debt. The debt typically is the loan used to purchase the property, but it can be any loan using the property as collateral to guarantee payment of the amount borrowed. The requirements for creation of a security interest in real estate are in Unit 8. When the purchaser of property borrows money to finance the purchase, the borrower, new owner, is the trustor, the grantor, of the trust deed. The trustee, the grantee, is the party who holds title until the debt is paid. The beneficiary, the California_E_principles_10E_book.indb97 the 23rd of May 2017 2:26 and 37 seconds p.m. 98 California Real Estate Principles 10th edition. Party on whose behalf the title is held is the lender. If the underlying debt is not paid, the trustee has the power to sell the property at a foreclosure sale and pay the beneficiary the amount of the remaining indebtedness from the proceeds. Any money left over would go to the trustor. The purchaser would receive a trustee's deed from the trustee. Reconveyance deed. A reconveyance deed executed by the trustee is the means by which the trustee returns title to the trustor when the debt is paid off. The beneficiary notifies the trustee that the debt has been cleared by sending the trustee a document called a request for reconveyance. Sheriff's deed. A sheriff's deed is given to the purchaser at a court-ordered sale to satisfy a judgment. A sheriff's deed carries no warranties. Tax deed. A tax deed is issued by the county tax collector if property is sold because of non-payment of taxes. Tax collection procedures are discussed in Unit 11. Transfer on death deed. A new form of non-probate transfer of real property was created in 2015 by statute, though the statute will be in effect only until January 1, 2021. A revocable transfer on death, TOD, deed transfers real property on the death of its owner without a probate proceeding, provided it is lawfully created. The grantor must have the capacity to contract to make or revoke the deed. The deed must be in the required form, and it must be signed, dated, acknowledged, and recorded. During the owner's life, the deed does not affect ownership rights and is part of the owner's estate for the purpose of medical eligibility and reimbursement. The TOD deed is only available for use on a residence of 1 to 4 units, a condominium, or a parcel of agricultural land of 40 acres or less that contains a residence. If, at the time of the owner's death, the property is titled in joint tenancy or as community property with right of survivorship, the deed is void. The law establishes priorities for creditor claims against the property owner and the beneficiary of the deed in connection with the property, as well as limits on the liability of the beneficiary. There is also a procedure for contesting the transfer of real property by a revocable TOD deed. The California Law Revision Commission will study the success of the TOD deed and make recommendations regarding its findings to the legislature by January 1, 2020. California_E_principles_10E_book.indb98 the 23rd of May 2017 2:26 and 37 seconds p.m. Unit 4 Transferring Real Estate 99. Exercise 4.3 What type of deed would most likely be used in each of the following situations? 1. All cash sale of a single-family residence. 2. Deed from possible former co-owner of property. 3. Loan secured by deed. 4. Conveyance from grandfather to grandson in consideration of grandson's love and affection. 5. Deed to someone who has just paid off a home loan. 6. Deed received after purchase of property at a court-ordered sale.